Okay, we're now moving into a public session, and to follow the row of Gactin and Shaw. Can I remind members about the protocols regarding the use of electronic devices? May I also advise those in the public gallery that mobile devices may be used through a Wi-Fi connection, and all devices should be muted, please. Password details are set out in the gallery rules for anyone wanting to connect to the Assembly's Wi-Fi network. 3G and 4G should not be used, and no recordings or photographs are to be taken. So can I ask, have there been any apologies received? Are members aware of any apologies? No. Okay. So I'd like to welcome you all here to this session. We are facing a longer meeting than usual today, and that is to allow us to consider a number of statutory rules following the extended absence of the Assembly, and this will allow us to move on next week to meeting with Department officials. I'd like to introduce and welcome Wendy Patterson, the Department Assembly Liaison Officer, who will be in the gallery at each meeting. You're welcome here, Wendy. Just before we get into the substantive meeting, I'd like to report on a meeting that Pam and I did yesterday with Nigel Hamilton and a group of other representatives from the Contaminated Blood Inquiry. I have to say it was extremely harrowing and deeply personal testimony that they shared with us, and I think that it's an issue of grave concern. We have encouraged and suggested to them that they make a formal approach to this committee to come along and explain the difficulties that they are experiencing and the situation that they're facing. Do you want to say anything on that, Pam?
Thank you, Chair. No, I think just in agreement with you, it was very powerful testimony from both those individuals, and I think it's absolutely worthwhile the committee hearing what's happening with that and considering, I suppose, Northern Ireland's position, where we are with that. I think it's something the Health Committee should be aware of and should take forward. And the other item to report in that section is that myself and Pam will be meeting with Minister Robin Swan this afternoon to have a discussion with him about how we as a committee can work with him in order to deliver on the health needs for our entire society that we have all agreed are paramount and that we all greatly desire to work on together to bring about those improvements. We will work with them, we will scrutinise the department where that is necessary, and we will advise and assist where we can. So myself and Pam will meet with Robin later in that respect. So in terms of the committee membership, can I ask members to note the details of the committee's membership, which can be found at page 30 of the pack? And can I also ask all members to complete contact details form and return it to the committee office for their convenience and for contacting you on an ongoing basis. Declaration of interests procedure, and I refer members to pages 31 to 33 of the meeting pack on the declaration of interests. All Assembly members are required to register relevant interest in the Register of Members' Interests, and I draw your attention that the deadline for registering those interests is 28 days from the date on which the member signed the roll. In addition to that requirement, Standing Order 69.5 states that a member who has A, a financial interest in any matter, or B, a relevant interest in any matter, must declare that interest before taking part in the proceedings of the Assembly relating to that matter. Members should note that proceedings of the Assembly includes meetings of this committee. As this is the first meeting of the committee, members should declare any interests held by them which are relevant to the work of the committee. It should be noted that failure to register and or declare an interest may be an offence under Section 43 of the Northern Ireland Act 1998. Before I ask members if they have interest to declare, I will declare my own interests. I have previously worked as a social worker and I am currently on a career break. I am also a member of the union NIPSA, and my wife is a registered nurse. And if any other interests occur in the process of our business, I will do, but I would like the members to know those from the outset. And I'll now go to Pam. I don't think I have anything to declare at this time. Thank you, Chair.
Just as I act as the Assembly Private Secretary to Naomi Long in the Department of Justice.
No, Chair, thank you.
No, Chair.
Don't know if it's relevant, Chair, but I'm a member of Unite and I have a relative who's a dentist, so just to make that declaration as well.
Okay, Ali.
I used to work in the South Eastern Trust. I wish to declare having relatives working in the health and social care system. Although not topical today, and it may come up, I have a close family relative involved in the Dr. Watt, hopefully investigation.
Thank you.
Chair, I have not yet been appointed, but will imminently be appointed APS to Robin Swan, the Health Minister. I also have a wife who's a social worker in the NHS currently.
Thank you. And as we discussed there, if a conflict of interest arises in the future, members can just indicate that as they arise. I would remind members that the rules governing the registration and declaration of interests are contained in the Code of Conduct and guide to the rules relating to the conduct of members, and that further advice and guidance is available from the Clerk of Standards, room 243 in Parliament buildings here. So, committee protocols then. The next item relates to committee procedures and guidance. Can I ask members to note the following guidance papers? Firstly, Guide to the Powers and Operation of Statutory Committees for Chairpersons and Members at page 35 to 45. Guide to the Role of the Chairperson at pages 46 to 52. Guide for members on the role and functions of the Committee Office at pages 53 to 54. In particular, I'd like to draw members' attention to guidance on privilege and matters which are sub judice. Under Section 50 of the Northern Ireland Act 1988, for the purposes of the law or defamation, absolute privilege applies equally to the making of a statement in proceedings of the Assembly and the publication of a statement under the Assembly's authority. This privilege also extends to meetings of this committee. Members should note, however, that privilege does not extend to press conferences or statements made to press. Committee members should be aware of the potential problems associated with discussing a matter that is sub judice, that is, a matter which is being or is about to be considered by a court. The sub judice rule is required by Section 41 and Schedule 6 of the Act and is contained in Standing Order 73. It provides that any matters arising in respect of which legal proceedings are active should not be referred to in committee proceedings, except to the extent permitted by the committee chairperson. In such cases, the matter awaiting adjudication should not be prejudiced by comment in a public session of a committee meeting. The rules relating to this are summarised in the Guide to the Powers and Operation of Statutory Committees for Chairpersons and Members. Chairpersons and members have been provided with those at pages 35 to 45. Can I now refer members to the guidance on timescales for interactions between committees and departments at pages 55 to 58? Okay. Are members content to note the guidance? Delegation now of technical scrutiny to the Examiner of Statutory Rules. Members are aware of the role of the Examiner of Statutory Rules in the technical scrutiny of statutory rule. Can I ask the committee to agree the following motion? That the Committee for Health, under Standing Order 43, resolves to delegate to the Examiner of Statutory Rules the technical scrutiny of statutory rules referred to the committee under the above-mentioned Standing Order. The committee further resolves that in carrying out this function, the Examiner shall be authorised to report her technical findings on each statutory rule to the Assembly and to the relevant department, as well as to the committee itself, and to publish her report. Are we agreed?
Great.
Agreed. Okay. So, we now we have a section of what are the item 31 that we could move forward to 31 and maybe start into the statutory rules immediately after lunch, rather than starting a few of them now. We have a short enough period there at lunchtime, so I propose that we move to item 31 and return to the statutory notes after lunch. Are we agreed on that?
Great.
Okay, so first, item 31 then is first day brief. I'd like to draw members' attention to the Department's first day brief, which they have supplied within the pack. It's in from page 439 to 482. It sets out the background information on the remit, the structure and the functions of the Department,
and related health and social care bodies. Are members content to note the paper ahead of the briefing from those departmental officials next week? Item 32, Committee for Health Legacy Report. Can I refer members to the Legacy Report of the 2011 to 2016 mandate at pages 484 to 502 of your pack, and to the Clerk's memo on pages 503 to 508 on the work of the 2016-17 Committee, including its work on strategic planning. The Legacy Report sets out the key activities, outputs and achievements of the previous committee and highlights a range of issues that it believed this committee may wish to take account of when considering our priorities for the time ahead. The committee may also wish to consider the 2016-17 strategic plan. Are members in the meantime content to note and consider this further once we have received briefings from officials and others? Okay. Moving on to our next item there, the forward work programme. Can I draw members' attention to the proposed draft work programme and schedule of briefings for the next 3 weeks at page 510 of your pack. I think it's important to note that we are in the context of there's been a backlog of statutory regulations to be dealt with, so our forward plan over the next number of weeks is taking that into account, and we're seeking to ensure that we get those items of business dealt with in a timely fashion. So, are members content to proceed with the briefings as set out in the forward work programme? And based on today's discussions, a draft covering the next 8 to 10 weeks will be provided ahead of the next meeting. Turning now to correspondence, can I refer members to page 512 to 533 of the meeting pack? I can advise members there are 14 items of correspondence at items 34.1 to 34.14 of the meeting pack, and 1 item of correspondence in tabled papers. I'd like to just draw your attention to a number of items there, and taking these first 3 in a group. Item 34.1 is a copy of the Minister's oral statement on the resolution of the HSE agenda for pay dispute that was announced in the Assembly. Also, item 34.4 from the Royal College of Nursing, requesting an opportunity to brief the committee on key nursing issues. And item 34.10 from the British Dental Association, highlighting the issues facing dentistry. Are members content to consider these as part of the forward work programme and seek briefings from the Department regarding agenda for change and wider workforce strategy issues? Great. Item 34.2 is from the Commissioner for Children and Young People, requesting an opportunity to brief the committee on the findings of the Commission's report on mental health services for children and young people to take place during Children's Mental Health Week. And I suppose we felt that there was a real priority on having that, so we thought that would be worthwhile bringing to members' attention at this early stage, even though there is all of the other things going on. So, are members content to invite the Commissioner to brief the committee?
Yes.
We're suggesting that we meet, or ask them to meet us on Thursday, 6th of February. Content with it. Item 34.3 is from an individual regarding mother and baby Magdalene institutions. Are members content to add this issue to the forward work programme?
Agreed.
Item 34.7 concerns the commitment by RQIA to carry out a review of the work of the neurologist Michael Watt. So what we have suggested that we consider that we write to the Department to seek an update on the progress of the ongoing reviews into that matter, and there are a number of members who agreed with that.
Yep. Sorry, excuse
Yes.
me, Chair. Some of us were also attending the independent inquiry panel.
Brett Lockhart.
Brett Lockhart, sorry, apologies, and Hugo Massey-Taylor. I think it would be useful if we also got an update and moved that from the sort of informal meetings we were having into this committee structure, because obviously that all links together.
Are there any issues with an inquiry in progress in that, Clerk?
I'll take advice and come back.
Thank you.
Chair, can I just ask, can we add our list of work that we try and, I know people have done it individually, but try and speak to some of the victims and the people going through the process, if we can, as best as possible?
Yeah, we can give that. Yeah, we'll see how we can facilitate. Yeah, take advice on that. Okay. Content then with that?
process. Our members, item 34.11 is from the Professional Standards Authority, highlighting the publication of its latest report. Are we content to note this for now and revisit it at a future date, as the committee will wish to look at the regulatory system in the health service in greater detail? We're content to, yeah. Item 34.8 is an invitation to the Chair to attend an information session on Huntington's disease on 26th of March. 34.12 is an invitation from Marie Curie and Queen's University to the Chair to speak at a consultation event on end-of-life care. And 34.13 is an invitation from the Stroke Association to the committee to attend the Rebuilding Lives After Stroke event on the 7th of February. I would intend to accept these invitations and will update the committee in due course. Are members content to note the remaining correspondence?
Noted, Chair.
Item 34.15 in the table papers is an email from a journalist in the Impartial Reporter, a newspaper, in relation to historic sexual abuse cases in Fermanagh. Are members content that that item of correspondence is considered as part of the committee's forward work programme planning for the coming months? And then any other... No, sorry, we'll move back to item 35 then, following the...
Chair, we have some time, so we could move to the statutory rules where we have no officials presenting. Okay, so that would be item 22.
Okay.
What numbers are?
So if we go to item
22 on page 332 of the pack.
Landry note on that, thank you. Okay. Yeah. So, the following three statutory rules relate to inflationary upgrading of cost recovery and voucher schemes. So, 22 is the recovery of health service charges amounts amendment regulations 2018. I refer members to pages 332 to 338 of your packs there. So, if so, can I ask members to agree formally? Yes, are members content with that statutory rule? Yeah, members content. If so, can I ask members to agree formally that the Committee for Health has considered SR 2018-195, the recovery of health services charges regulations, and subject to the Examiner of Statutory Rules report, has no objection to the rule? And just for clarity, Clerk, are you saying that is that strictly only an inflationary matter? Rule 22.
If the committee would like further information, we can put that together for them for next week. But that was the impression on reading it. That's the explanatory. You can look at the explanatory memorandum on page 338. 336, pardon me, it explains the purpose of the rule to increase the charges recovered from persons who pay compensation in cases where an injured person receives health service, hospital treatment or ambulance service from the 19th of December 2018. The increase in charges relates to an uplift for hospital and community health service annual inflation. And if you look at the preceding page, 334 is the actual regulation itself, and it shows you the substituted amounts. So for £201, £208 will be substituted. And I understand this is in relation to incidents where the health service is able to recover money, for example, from an insurance company, should there have been a car crash in which one person was liable and another person received treatment. The health service could then recover charges.
So it's really it doesn't introduce that as a concept. It's more an inflationary rise. So are members content then?
Yes.
Yeah. Okay. 23 then, I refer members to pages 339 to 347 of the pack, and that is, let's have a where are we at?
The Optical Charges and Payments Amendment Regulations 2018, and again that's the explanatory note on that. Where is that? Clerk?
So 339 to 347. The explanatory memorandum is on 346 to 347. That's another inflationary uplift regulation.
So are members content with the statutory rule?
Content.
So I'll put that then. So can I ask if members agree to formally that the Committee for Health has considered SR 2018 to 2000/2011, the Optical Charges and Payments Amendment Regulations and Northern Ireland 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule? That we have no objection.
Agreed. Yeah,
Right.
agreed.
Okay. SR 2019 to /29, the Recovery of Health Service Charges Amounts Amendment Regulations, Northern Ireland 2019. I refer members to pages 348 to 357 of the pack. And we just quickly check that that's similar. What's this one dealing with?
So this is another inflationary uplift,
Okay.
as explained in the explanatory memorandum 352, and the actual rule on page 350, the substituted amounts in paragraph 2.
Okay, so hang on this. This one here.
29.
So if so, can I ask members to agree formally that the Committee for Health has considered SR 2019/29, the Recovery of Health Services Charges Amounts and Amendment Regulations, Northern Ireland 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule? Agreed.
Sorry, just on our financial implications, it says that an average motor insurance policy could be expected to rise by around 46p per policy. I know we're the Health Committee, but we have no. Is there any way of regulating that the insurance company can't go any higher than 46p per policy, or is that just there's no?
The Chair can try and get some further advice for the member, but as she rightly says, that information you're pointing to is what we're being advised could be the possible outworking of the health service seeking to recover charges, and those charges being passed on by an insurance company to its clients. So it's quite a remove from the committee's remit.
Yeah, it's okay. Thank you.
We need to. Yeah, we need to complete this one. Yeah. So, which one are we on here? No, that's the one we just. 25. Yeah. So the Committee for Health has considered SR 2019/109. No, sorry, that's not. Yeah. Well, do you know what I think has happened there? I think we've actually missed out on this one, and I think I need to put that to the committee again. 22 we have dealt with. 23 we have dealt with. So we're on 24 now. Yeah. The Committee for Health has considered SR 2019/29, the Recovery of Health Service Charges Amendment to Regulations, and subject again to the Examiner of Statutory Rules report, has no objection to the rule. Agreed?
Agreed.
Yeah. So I suggest that we now suspend our proceedings and return maybe at 1:30 to pick up again. May I ask members to return at 1:30? Thank you.
Lunch will be available at 1 o'clock.
Okay, members, thank you for coming back to us. We're now picking up where we left off this morning's session, and I refer members to the Clerk's memo on pages 60 to 62 of the pack. We have 42 statutory rules on which we need to come to a view by next Thursday in order to comply with the statutory period for consideration. We have 26 on the agenda today.
and we'll consider them grouped into themes to make it easier to follow. Where possible, officials have been invited to brief us in respect of the substantive regulations. Should we have any questions that cannot be answered today, we can defer any decision until next week. The first group of statutory regulations which we are going to consider today are around the mental capacity regulations. And we're dealing here with 9 regulations, and we're starting there at page 63, and it's going to take us right up to page 229. But these regulations deal with the deprivation of liberty under the Mental Capacity Act 2016. Given the complexity and the significance of these regulations, I would now invite Thomas Adele from the Mental Health and Capacity Unit in the Department of Health to brief the committee on their net effect and update members on implementation of the deprivation of liberty aspects of the Mental Capacity Act. So we invite Mr. Thomas Adele. Thomas, you're very welcome here.
Thank you very much.
And thank you. And if I could just ask you to go ahead and brief the members on the regulations dealing with the Mental Capacity Act.
Yes, so thank you very much for having me here. I'm going to do a quick background to what the Mental Capacity Act is and why we're doing this, and then explain the statutory rules in a little bit of detail. So, the European Convention of Human Rights, Article 5, provides the right to liberty. The article provides that a person can only be deprived of liberty for specific reasons and in accordance with procedures prescribed by law. A judgment by the UK Supreme Court in 2014 highlighted the issue and provided an acid test for when a person is deprived of liberty, as a person is under continuous supervision and control and not free to leave. The Supreme Court also noted that all of these incidents must be authorised. Without the statutory rules and the deprivation of liberty safeguards found in the Mental Capacity Act, the only way of doing so is in the mental health order for people in hospital who are mentally unwell, or after a decision by the High Court in Belfast. The Department of Health estimated there are approximately 7,500 people in care homes, nursing homes and supported living facilities that are deprived of liberty every year, and an additional 10,000 in hospital. This does not include mental health detentions. And in recent years, there have been less than 50 declaratory orders per year by the High Court, meaning we have a gap between what's authorised and what's not authorised. This provides some significant risks, both to patients and residents, to healthcare care workers and to the system as a whole. So without the framework, there's a risk of the human rights of the persons of arbitrary detentions. So preventing someone leaving is common practice in care nursing homes for very good reasons. This prevents someone suffering harm when they don't know what they're doing, and that there's nothing wrong with the concept behind this. However, without the framework to make sure that only the right people are deprived of liberty, there's a risk that the wrong people might be. There's also a risk to health social care workers, so the staff on the front line who are carrying out this deprivation of liberty. Without a statutory framework, or without a framework or High Court order, there is nothing to protect them from liability, both criminal and civil liability, or I should say potential liability. There's also a risk to the system. European Convention of Human Rights, Article 5, provides the rights for compensation when there's been a breach of Article 5. In recent court cases in England and European Court of Human Rights, have noted compensation of approximately £100 per day per person when there's been technical infringements to Article 5. So, to do something about this, the Department of Health has been seeking solutions for a number of years, and the conclusion are there are 2 options. One, we can either seek High Court authorisations for all cases, or we can provide a statutory framework which can authorise these cases. It is estimated that a cost to the healthcare care system in financial terms to seek High Court authorisations for all cases would be in the region of £40 to £45 million a year. This does not include cases in hospitals or costs that the High Court would incur in legal costs of judges and so on. It would also take a significant amount of staff time, healthcare care staff time, to go to High Court to present their cases. On the other hand, the cost of commencing the Mental Capacity Act for the purpose of deprivation of liberty is estimated at approximately £3 million per year. So it's significantly cheaper. So balancing the risks that we currently have with the lack of protections and the costs, the Department of Health and Justice were working towards commencement of the Mental Capacity Act, and initially in April last year took the decision to commence on the 1st of October last year. Commencement work began immediately. However, in the weeks before commencement, the Department of Health received strong representation from the trade unions that the trusts were not ready to commence on the 1st of October, and the decision was taken to delay commencement to the 2nd of December to provide more time for the system to get ready. To enable commencement, the Department of Health made a total of 9 statutory rules, 2 commencement orders and 7 regulations. 2 of the regulations were revoked because of delay in commencement, and 1 regulation was revoking those 2 regulations. The 4 remaining regulations provided provisions for research, money valuables, deprivation of liberty, and a small amendment to the deprivation of liberty regulations. The main regulation is the 2019 number 1 and 9, which is the deprivation of liberty, mental capacity deprivation of liberty number 2 regulations. These regulations provide practical and technical details for people who are carrying out deprivation of liberties and how it can happen. So it provides who can provide certain duties, which professionals can make formal assessment of capacity, for example. The format and forms of applications, that includes 15 statutory forms, and what information is needed and to when they should be provided. So if someone is deprived of liberty, they should be informed that they're deprived of liberty. How the trust panel, which is one of the authorisation mechanisms, how they work and who the members are. Arrangements when a deprivation of liberty happens, someone who is under 16 but is going to turn 16, as the Act only applies to over 16s. And transitional arrangements, how the Mental Capacity Act relates to the mental health order to make sure there's no overlap and conflicts. The decision to commence was taken in April last year, with commencement date 1st of October. It's a very, very short time period. And the work on the statutory rules had been started before then, but was continuing after that point. Throughout this period, the rules were co-produced with professionals, users, interest groups, and significant others. The department has a virtual reference group for this work with over 350 individuals, which includes organisations, individual people, and representatives from the community vulnerable sector. The work on the rules, the code of practice, and other documents have all been done in conjunction with this group. We also decided we need to learn from experience of similar legislation in England, and there's been a significant amount of preparatory work. So we provided a code of practice, which was aimed to be as simple as possible and as short as possible. It's still quite a significant document because of the scale of the legislation, but we tried to make it as short and simple as possible after consultation with professionals and what they actually want to know about. We also provided significant training. The department created a training program consisting of e-learning and classroom-based training. To date, there has been over 40,000 hits to the e-learning training, and over 6,500 individuals have attended 16,000 classroom-based training instances. We also created a scenario booklet with real-life scenarios to help people get a flavour of what to do in certain settings, and that's something we're continuously updating as we get more information. And we provided leaflets and similar things for people who may lack capacity or their relatives. It's undeniable there's been some impact on the health social care services, staff, and the sector in general because of the Act. So the department expects there will be approximately 7,500 of these authorisations in the community per year and 10,000 in hospital. Each deprivation of liberty requires consideration of a health social care professional, which will take time. However, it's worth remembering why this is done. It's there to protect the people from arbitrary detention and protect the staff from liabilities that otherwise would occur. So in the first 6 weeks since 2nd of December, there's been 223 applications for community deprivation of liberty and 102 short-term detentions. And this is what we expect at this point as we continue ramping up. We are continuously reviewing implementation and have 2 regional groups to meet monthly to discuss issues and how we can take things forward. And it's accepted there will be teething problems. It's accepted that things will not work perfectly, but we're committing to reviewing the implementation as we go on and have a formal review at some point later on this year or early next year. I can talk about the details of the regulations as you seem fit, and I'm quite happy to answer any questions you may have.
Well, I suppose just you mentioned there the two regional groups involved.
Yeah.
What's the makeup of those groups, Thomas, and who's involved in those groups?
The 2 formal groups we have one group which is the Health Social Care Trusts, and the board is focusing on delivering this in practice. So it's delivery questions, so how do they work with their professional staff and so on. A second regional group that consists of the Attorney General, the Review Tribunal, which again looking at teething problems from the practical elements on those sides. In addition to this, we obviously work continuously throughout other processes with people who have lived experience and people who may people who work with people who lack capacity. One of the problems we have when it comes to user groups is that this affects everyone in some extent. We can't draw it into one box, and therefore we're trying to work very widely with as many people as possible.
And you also referred earlier to having discussed with the unions issues that they had around training, one thing or another. And I know there was a later mention of other groupings, but can you just clarify what consultations were done in total, or how you consulted on this with the sector?
So the regulations went through to this reference group for informal consultation in spring of last year, or so end of spring last year, and this includes some of the trade unions. We recognised when the main trade unions contacted us that we could have been more proactive in working with them, and we met them a number of times since, and we are still continuing meeting them as they want to meet us. We realised we could have done more, and hindsight is a great thing, but we're at least working forward with the trade unions at the moment.
And what consultation was there with the public, or with people who are affected, or advocates, or family members?
So the policies about the operational liberty in itself was consulted on publicly as part of the Mental Capacity Bill in 2014, and the main policies are in the Act. The regulations are more technical. There are a number of user groups on our reference group, and they were consulted through that process.
Okay. Thank you, and thank you for that presentation. And I suppose we all acknowledge the huge complexity and the important issues at stake here, and I suppose that will be reflected in the members' questions, because we are really dealing with serious issues here in terms of depriving people of their liberty. It's definitely a complex, challenging task for all concerned in relation to health and care staff, and we know they're already extremely stretched. So I suppose I would like to maybe open up now to members to ask questions. I have John indicating here at this point, Sinead, then Jerry. So, John.
Thank you very much, Chair, and Thomas, thank you very much for your presentation. I think we'll all agree it's a very sensitive subject, and not something that care workers or anyone in the medical profession would want to be doing unless the situation required it. You talk about, the Chair's already alluded to some of the consultation that you've done and satisfied the response on that. You referred to the code of practice that's been adopted from England based on their experiences there for the workers. Can I say, in terms of best practice, what have you learned from the experiences of other areas of the UK in terms of their experiences that have rolled this out, and how has that updated the regulations that we're looking at today?
So, if I consider first code of practice, one big thing we learned there was the code of practice in England was too big and too detailed on some things that professionals don't need. So the code of practice we have is much slimmer, much straight to the point, and with simple flow charts and similar things that way. It's still a hefty document because of what we're dealing with. Of course. But we try to make it as slim as possible. The big thing, learning from England and other jurisdictions as well, is support for the workforce. So the regulations were not hugely affected by this, but the training program we provided was the biggest effect, learning from England. By training 6,500 people is roughly 10% of our workforce. We've trained a significant number of people, and we made the training available free of charge for anyone who wanted to attend. So this was the same for the statutory sector and the independent voluntary sector. This training was delivered in half-day modules, and there was a compromise between the length of training and how much training to get people through the training. And the view was that it's more important to get many people through training, that they have awareness of the issues. So that's why the training was half-day sessions. The regulations were informed by, we were trying to make it as streamlined as possible. So the big part of the regulation are the forms, so the statutory forms that must be used. There was strong views from England that there should be statutory forms and regional forms, not left up to each trust to make their own forms, because that caused confusion among professionals and people and relatives. So the forms are statutory, but we also tried to make them as short as possible, so to cut away any unnecessary information. They were capturing the rights issues, the risk issues, and then the balance between the rights issues and the risk issues. And that was developed with the professionals in mind and with their input, and there were some piloting on these forms both after the decision taken to commence for these purposes and before that.
Okay, thank you very much. Thank you, Chair.
Sinead.
Thank you for your presentation. I hope you'll appreciate this is quite developed at this stage, so for us taking, I suppose, a first sight of it, it is a bit overwhelming in terms of the volume of content that's there. And so some of my questions may actually go back to the original intent, and even, you know, one of the things that jumps out to me here is the formal assessment of capacity, the nominated persons, and the logic that it would be, for example, a registered dentist that would be able to make that assessment. And I accept that that's not the report, it is the assessment. So if I could just be a bit more informed on that. And I notice this isn't the commencement part. I suppose when we move on to the money and valuables one, where, you know, elder abuse and things like that have to come to mind, and have some concerns in there that maybe I'll raise as we maybe work through it further. But that first piece,
yeah,
where you have people like a dentist making an assessment on mental capacity.
So when we decided or worked with the professionals and others on who this group should be, we looked at what are the core competencies of professions. So by going through, looking at their training programs, looking at what they do in their lives, and the conclusion was that the group we have is the group people have the core competence to be allowed to do this. In addition to be this group of professionals, you have to go through the specific training for deprivation of liberty, and that should only be done if it's relevant to your profession. You must also be nominated by your employer as being a person who can make these assessments for the purpose of deprivation of liberty. It is accepted, it's very, very rare that a dentist will do a deprivation of liberty. There are, however, some circumstances, especially when it comes to people with severe learning disabilities, and they need significant dental treatment under general anesthetics, where this may become relevant. So instead of excluding a group that we thought had the core competence, we decided to include them with the expectation that most dentists will have no involvement in this. But for those few that will, they should be allowed to do so, because they have the competence to do it.
Thanks, Thomas, for your presentation. Just 2 comments and then 2 questions. My understanding is there's still a concern amongst health staff, or some of them at least, the training isn't there, or they're not aware of it, or there's confusion whether they bring themselves forward for the training, or whether it's down to management to instigate that. So a comment on that, please. And obviously it goes out saying that, you know, people in hospital beds that should be there, they should be maybe in other facilities. It's pretty much a given and an important thing to happen, and it obviously would mean potentially taking beds away from people who would need them. My concern would be that if there's no facilities outside of the hospital, so for talk's sake, if somebody's in a hospital environment and it's deemed that they should be going elsewhere, but they're maintained because there's no other facilities outside the hospital setting, so I would be concerned potentially about that. And just 2 other questions, Chair. I think it's in the document, but if you could just clarify if there's a unlawful deprivation of liberty, or a suggestion that it may be unlawful, how can that be challenged? And I think there was consultation in 2016, I think, and certainly maybe in England. But if you could comment on the consultation in terms of how many responses, to the best of your knowledge, was there, and sort of was there any other issues or raised? Because I think it is, as others have said, it's a very serious issue, and it's come to us quite sort of rapidly. But if you could ask or answer some of those questions, that would be important for me. Thanks.
Of course, yeah. If I missed something here, please correct me. Sure, yeah. So first, the workforce and the training. Yes, it is a challenged workforce, and the workforce is very stretched. We fully accept that. There's been some confusion on the training, and we try to clarify that as we go on. The training is set in a situation before, so we trained between September and December, so before commencement. So training was necessarily quite theoretical, because we didn't have real life cases to use in the training, and that has been what the feedback we've got. That's been the biggest problem. Satisfaction with the training has been very high. It's sitting at about 95%, but with a comment that it's theoretical, not practical. Mm-hmm. As we move forward, all health social care trusts have made commitments that they will adjust the training to make it more practical, because now there's practical cases to use in training, and that's part of the problem we have when we have a big significant piece of legislation that's being brought in without anything similar existing. There's also been a lot of nervousness in the workforce that has been trained that they're doing something not used to. What the experience so far has been that when people are doing it, they're suddenly saying that, well, actually training makes sense. But until you do it, it's really hard for staff to get that reassurance. So a lot of the work we're trying to do is to build confidence in the staff workforce, and to have the trust to provide support and help for them. There were 21 staff seconded to the department to deliver training. They've all gone back to the trusts, and some of them were delivered training in the trust, and have been working as mental capacity champions in the trusts for other staff as a resource to help them out. The Mental Capacity Act should not lead to delay in discharge. It should not lead to people staying in a bed just because there's no paperwork in place for the right thing. The Act provides for emergency provisions, and the emergency should not be interpreted or read in the dictionary definition of emergency. The emergency is when delaying the Act, i.e. the deprivation of liberty, because the safeguards, the authorisations are not in place, will cause an unacceptable risk of harm to P, or to a person, then the Act can be done without the authorisation. If the case is about delaying discharge, it's better for the person to be, say, in a residential home than a hospital. If that's a decision taken, it would be a risk of harm for the person to stay in hospital, and then you can discharge them and get the paperwork and authorisations done retrospectively. That's allowed for in the Act, so that should not be a problem. There has been some instances where this has happened now, where we have quickly worked with guidance and extra support for the trusts and care homes to prevent it happening again. The detention is unlawful. There's a number of ways to challenge that. There's a criminal offence in the Act that comes into force on 2nd of December this year that makes unlawful detention a specific criminal offence under the Act. That is obviously a nuclear option, so someone can go to police and report unlawful detention. We would hope that that wouldn't be used, because there shouldn't be unlawful detentions. Otherwise, there's always the normal civil remedies, so such as seeking compensation for false imprisonment or taking those actions. In general, when something is in the health services, the laws aren't followed, there can also be judicial review sought, and those remedies. RQA are implementing this as part of their inspection regimes. So while they might not look at individual cases, if they find systemic errors in their inspections, that's something they will raise. It is possible the department can seek RQA's views to do formal review on the work, and the department is certainly monitoring what's happening on a systemic level to make sure that these things, that it won't be unlawful detentions. A lot of these regulations, the work on these started immediately after enactment of the Mental Capacity Act 2016, so a lot of the policy work behind them. At that point, we were again informally consulting with a large number of with a reference group, a large number of people. And the initial round, we got over 1,500 comments, individual comments, which were used to shape the next set. These versions are the 4th draft of what we started, the work we started in 2016. So we have been trying to work with the sector and with users and with care groups and others to make sure that this is right. The last set of informal consultation we had, the comments were largely positive, and there was no significant concerns about the contents of the regulations. The issue is about the concept of the Mental Capacity Act, not about the contents of the technical aspects of who can do what and the forms and so on.
And George, finally, can I ask, in that consultation process, were groups who work with vulnerable people, vulnerable adults, were they involved? Have they had input into this to the best of your knowledge?
Oh yes, it is a significant input from a number of people. The list is large, but it includes groups like Action Mental Health, Inspire, Mindwise, Alzheimer's Society, Compassion in Dying. I mean, there's 350 groups, and that a lot of those groups are community groups and charities working with people who are vulnerable, or working with carers who are working with people who are vulnerable.
Thanks, sir.
And just as a follow-up to Jerry's first question, what percentage of staff are currently trained in this, and when is it, or if not 100%, when is that due to be completed?
So the latest data I have on the e-learning packages we don't track individual people, but it's been over 40,000 hits on the e-learning. So that's a significant number of the about 65,000 workforce that exist. 6,500 individuals went through the training that the department provided for free. So that's 10% of the workforce. In addition to that, training has been provided by the trusts, and the trusts are continuing delivering training, and the independent sector are also delivering training. So we know that at least 10% of the workforce has gone through formal training, classroom-based training, but we also know there's been a significant number of others that we don't have numbers for.
And what sort of plans are in place to bring that 10% up to? I presume that wouldn't cover for all eventualities. So what plans are in place to expand that?
We think that the classroom-based training, there should be between 10 and 15% of the sector that should be trained in classroom-based training, because they're the ones who will be directly involved in making the decisions. The e-learning and the general training, we won't bring that up to 100%. and we're close to going there. We're providing the e-learning for free. We're providing training materials for free for the trust and the independent sector. And by doing that, we're encouraging them as much as we can to take up on this. We think we're close to getting there. The awareness among independent sector nursing home care homes is very, very high. So it's about getting all their staff to know the details. The awareness in the trust is very high. All trusts have created implementation leads and have a lead director appointed to drive this work. So by encouraging these sectors, we want to be as encouraging as possible, not to provide sticks, but to provide carrots. And by providing the resources for free, we're doing the best we can.
Okay, thank you. Paula?
Thank you, Tomas. I'm just wondering about any differences between what's being proposed here and what is in England and Wales. That's the sort of broad question. And then the second one, you mentioned about the savings, the financial savings from not having to make the order to the High Court. But I'm also then wondering about the time savings of how these protocols will save in terms of getting the orders in place.
So, start with England and Wales. The system in England and Wales is significantly different. And the biggest reason for that is the integrated health care system we have here. In England, they have different authorisation routes depending on where the person is. We have two options, either in hospital or if someone is in hospital, it can be short-term authorisation, lasting 28 days, or it has to go through a trust panel that approves the authorisation for up to 6 months. They can be extended. In England, they're reviewing the Mental Capacity Act and the Deprivation Libre Safeguards, and that passed last year in House of Parliament, which is coming. The intention is for it to bring that into force on the 1st of October this year. While that's a much better system than they have now, we still think that our system is more streamlined and more straightforward, and that we have put the responsibility to making all the paperwork to the trusts. So the trust make the paperwork, the trust make assessments, the trust consider the case. With independent checks, the trust consider the case, which means it's one organisation that's responsible for one system. And that's a significant learning with the confusion from England. We also have very strict timelines that after trust receive an application, they have 7 working days to make a decision, and there's no leeway or exceptions, no acceptable delays in that. In England, there is no set timelines in the same way, and they have a significant number of cases who've been delayed for a very long time. We obviously will work with the trust to make sure that they can meet that as well. The other question was about...
Well, I think you've pretty much answered it in the second part there around the difference in time between going to court and...
Sure. So, I mean, the big problem with the court system, I mean, the cost we have for going to court is estimated cost because it doesn't happen. So it's not the real cost at this point. It is accepted that if we make 7,500 applications to the High Court probably couldn't cope. And looking at the cases that are going, they're spending a significant amount of time just attending court, in addition to all reports and assessments that has to be done. We estimate that the Mental Capacity Act would save significant staff time. It's hard to quantify exactly, but maybe we think it's significant many hours savings per case by using the Mental Capacity Act rather than going to court for every case.
Okay, thank you. Thank you, Chair.
Orlia?
Could I, just before I ask Tomas a question, can we ask a question on any of the statutory rules, or do we need to do it in a certain order, or am I okay to just cover the issue as a whole?
Are they within this section?
The mental capacity, yes.
Yeah, absolutely. Yeah.
So thank you. Yeah, there was a few wee things. So it's referenced a few times in the document around some of the safeguards that have been put into place. Particularly some of the ones that stood out for me was in and around, the transitional arrangements for the seamless transition if for a 16-year-old or someone who hasn't just reached 16, but having those arrangements in place so it was seamless. But it was referred to that safeguards and additional safeguards would be in place to allow that process to be seamless. So it was just to maybe see if there was any more detail on what those safeguards consist of, or is there a benchmark on what safeguards you have to use. And it was also referenced in relation to the finances, if a residential care home or a nursing home was going to manage someone's money. Again, it was the term was used, it would be in certain circumstances if certain safeguards are in place. So it was just to see if there was a wee bit more detail on that. The issue around the money also, I didn't see it mentioned anywhere, and I'm sure there's a reason for this, but that family or next of kin would have access. It was really just referenced in relation to the residential care or whoever is working staff in the nursing homes. So was there a reason why families or next of kin aren't referenced? So that was just the first issue on the safeguards. Then in and around the consultation process, I know that the department did informally brief the parties as well around that time whenever these issues were flagged up. So I know that was done. But was there any consultation at the time with the Human Rights Commission? Now I know that the clerk and the chair had explained earlier that we'll be getting a report from the technical examination report next week. But it was just maybe to ask if any of that consultation was done with the Human Rights Commission at the time of drafting up the statutory rules. And you had also mentioned about one of the main unions that maybe weren't heavily involved at the beginning, but you are speaking to now. Did they flag up any, because it is quoted that at the time during the consultation there was no significant issues raised, but since having that, since having those conversations with whatever union it is in question, have they raised any significant issues that may have been missed at the time? And then just finally, there was something that stood out for me, again from a human rights perspective, but I mean it could be off course with this, but in relation to the research being carried out, it quoted that if the person lacks capacity, he or she is unable to consent, but that research can go ahead without the person's consent. And I was just wondering if you could elaborate on that a wee bit for me. And I know that was a lot, so sorry.
If I miss anything, please correct me.
Thank you.
So starting with under 16 to over 16.
Yep.
So the Mental Capacity Act is age neutral for anyone who's over 16. So it applies to anyone over 16, and it applies to the same for a 16-year-old as it does to an 85-year-old. We have an arrangements for people under 16 who are coming into a situation of Mental Capacity Act, which means the safeguards can be applied and the process can happen in the month before the person's 16th birthday. And there's for practical reasons. So if on their birthday they need to be deprived of liberty, and they're in some other setting, or it's known they're going to be deprived of liberty, you can ensure the process in place before they turn 16. That doesn't mean that the deprivation of liberty can happen before the 16. But you can make assessments and make consideration for trust panel application. So that's a big difference. The Act does provide for additional safeguards for people under 18 who are treated for mental illness in hospital, and it's quite specifically for mental illness in hospital, or mental disorders in hospital, that there must be an age-appropriate accommodation. And that means that hospital management must consider the age appropriateness of where the person is, so that it should only be treated in adult wards if it's appropriate to do so. And it might be, for example, that the adult ward is closer to their own home than the specialist children units, and the family ties are more important. Or there might be other specific things, but there must be consideration of their age. So children can't be put in adult wards when treated for mental illness. But it's very specific about mental illness, not deprivation of liberty in general. When it comes to the money valuables, the money valuables regulations are very specific. It relates to care nurse homes receiving or holding money valuables, only, and expending and using them for the best interest of the person. It does not allow the managing authority to access to bank accounts or benefits or any of those kind of matters. And the money valuables cannot be used to pay fees or anything else that would normally be included in fees. Then the purpose is essentially if a person turns up or being taken into a care home and they have cash in their pockets, or if they have, say, an expensive wedding ring, that the care nursing home can legally hold those, which they can't without these regulations, and that they're also liable if they lose the money valuables. So it's a very, very small, very narrow, specific purpose. For families and other residents or other relatives, there is provisions through enduring powers of attorney and in normal court processes to get controllerships and court orders, and that's the safeguard for that. Okay. This is a very, very narrow purpose. and that's why it's managing authorities only. When it comes to the consultation in the Human Rights Commission, they're on our reference group, so they would have been copied into all information, they've been included at all points. And I believe we have got comments from them, but I'm not going to guarantee that because there's been a lot of comments, but they've certainly been copied into information.
Okay.
When it comes to trade union side, so some of the trade unions were involved on the reference group from the beginning, and we realised when they processed it we hadn't included some of them. And their biggest concern was not around the concept of the Act or the contents or regulations, but when we're commencing and the readiness of staff. So it's about training and it's about timelines and about workforce pressures and pressures in the health service in general. So the unions were not negative to the concepts, but how it was done. And we're working constructively with them, and they've been invited to our regular meetings. The research provisions relate to people who lack capacity, and it's intrusive research, but it's not a clinical trial. And so there's a big exception there straight away. Clinical trials are regulated separately. So if it's clinical trials for testing of medication or testing of procedures, it is not covered by the Mental Capacity Act. So these would cover things that we normally require consent, but a person can't consent, and it's not a clinical trial. So that would be using their data, blood samples or tissue samples. That's the main issue, main areas. So while it's called intrusive research, it's not intrusive in terms of clinical trials or testing new surgical methods or those kind of things. That would be a clinical trial. And any research that's done must be done in the person's best interest, and it must be deemed to outweigh their interest over the interest of science. So the person is always at the centre, so that their rights are protected. Under the Mental Capacity Act, best interest shifts slightly from clinical best interest to a holistic best interest. There must be consideration of the person's special regard to his person's wishes, feelings, beliefs and values. That means that if you have someone who is very much in favour of research in general, it might be deemed when they lack capacity that actually they would probably have said yes because they liked research. Then they can take part in research under the Act. But it's their interest is always paramount. It's not the interest of research, not the interest of science. It's what would they want to happen if they had capacity to consent. So it's focusing on that aspect. So we think that it's stronger human rights protection for people now than it would have been before when it was based on the common law and more focused on a clinical decision making and decision making around people on a different scale. The concept behind, in general, they also says that research can only be done if people lack capacity if it's not practical to do research on people with people who have capacity. So if the same research can be done without and not including the people who lack capacity, you can't include the people who lack capacity. So the focus is always find people who can consent. If that's not possible, consider if it will benefit the patients. If it can't benefit the patient, then it can be done anyway. I hope I answered all your questions here.
Yes, you did. Thank you very much. Thank you.
Thank you. I want to move on to that section of the thing as well about the research. And I know we haven't had the examiner statutory rules, but I was a little alarmed at the bodies that would be appropriate bodies would be a HSE trust or a university. So I'd like to just have some thoughts on that a university could intervene at that. I could understand sort of from a medical perspective, but a university, to have clarity on that. You do mention as well, it's in the document on 225 mental capacity, where it cites the amounts, and it just refers to section 26763A of the Act on how much. So I just don't know the scale, how proportionate is this in terms of how much can be held under these regulations. It also goes on to talk about a nominated person if one is appointed. And, I just want to know how exhaustive is the process in ensuring a nominated person is appointed in every case where it's possible. And then finally it goes down to say under section 7 of that a counter-signature of another person witnessing the signature in subparagraph K. So subparagraph K was referencing the person within the place, wherever the patient might be or the person might be. But there doesn't seem to be any sort of, pinning down on who that counter-signature is or could potentially be. And I'm just thinking in terms of the vulnerability of the patient here, that it doesn't even stipulate that it would have to be another member of staff in that place. So I just wonder, is there a reason behind that? Am I missing something there? I think that's me for now. Thank you, Chair.
So when it comes to research regulations, the people who carry out research that would be relevant here in Northern Ireland are the universities and the health care trusts. The bodies that would approve research in Northern Ireland is the HSE research ethics committees that sits under PHA, and the ethics research bodies that sits under the two universities, so under UU and under Queen's. So they have research bodies and research operations to approve the research, assess research, and it was the policy intent that those people will be allowed to approve the research in this aspect as well, as part of their ethical consideration of the research in general.
Okay.
And they will be bound by the normal ethics considerations that they have when they carry out research. I mean, those bodies are the experts in research and ethical consideration of research in Northern Ireland. When it comes to the amount in Section 276, that's set in the Act in the primary legislation as £20,000. The reason of £20,000 is it's not, the intention is not that they regularly hold that, but they're permitted to hold up to that amount. If someone comes into a care nursing home with a wedding ring, the wedding ring might be worth £10,000. If the wedding ring can't fit on a finger because the finger is swollen up, the care nursing home should be allowed to safely keep that wedding ring in a safe. Or you have a painting on a wall that belongs to residents, unless they have the power to keep those, that they can't keep them in the home, and there's no responsibility for the home to keep them safely. So that's the reasons for the values. The value was provided through consultation process of the Act when it was a bill in 2014 in a full public consultation, and it's my recollection that at that point £20,000 was deemed a suitable figure for care nursing homes to hold without approval from the RQI. But I mean that figure is set on the face of legislation, not in the regulations.
Yeah, I appreciate that. Yeah.
The appointment nominated person. So for the purpose of money valuables, you need to consult people when they're considering best interest. The best interest requires that all relevant people are consulted. If there is a nominated person appointed, they are one of the relevant people, and then they must be consulted if it's appropriate and practical to do so. That's on the face of the Act. So if there is a decision that requires a nominated person, there's a default list on the Act. So you start with the person's carer, primary carer, if that's a non-paid carer, and then it goes to spouse and child and so on. So there is a default list, so who the nominated person is defined. Yeah. When it comes to counter-signature, and that's 7K you're referring to?
Yeah.
Yes, yeah. Just make sure.
Sorry. L, 7L.
Yes, L, yes, yeah. Yeah, and the signature in K, yeah. So the intention behind this is that the person must keep a record of what they're keeping, and that one person themselves can't make a decision, that there must be someone signing for it and someone counter-signing for it. It can be difficult to find exactly who they are. If they have agent staff, for example, they're not employees of the home. So the policy view was that if someone signs for it and someone else counter-signs for it, it's still the managing authority's responsibility that the right people sign for it, and the managing authority is responsible for what happens with that fund. So if someone has signed for it and it's used inappropriately, it's the managing authority responsible, not the person signing. Okay. So it's their interest to only have the right people signing.
Yeah. Okay.
Gemma?
Yeah. Thanks, Chair. Thanks, Thomas. Just 3 quick questions. It says on the trust panels the duty to record and retain information and records, that it says to keep the records for as long as is relevant. Who decides what is as long as relevant? You know, sometimes we've come up with issues around detention and safeguarding. This could be an issue. I know it says that at least 1 year from the panel decision, but after that, who decides what is relevant? The other one was on clause 45, arrangements when a deprivation of liberty is proposed before a person is 16. The length of time is 1 month. And what was rationale for 1 month and not 3 months, considering some of the issues around waiting times and waiting lists? And that's me, actually. Yeah, just 2.
So on the first thing, the trust panel duty to record and keep information, they have to keep it for at least 1 year, or as long as relevant. And that should be, the intention is to keep it in line with normal retention procedures in the trust. So as long as there's a detention ongoing, they must keep the records. But after detention is ended, they must still keep it for a year after authorization. But they can then destroy the records as they would destroy normal records in the health service. Yeah. So it's within normal retention procedures. When it comes to 1 month transitional provision, the 1 month is the time period when you can make a decision. And make the assessments to make a decision to deprive someone of liberty. So we would want those assessments done as reasonable as practical, or as soon as practical before the decision to deprive someone of liberty. So if someone is 15 years and 9 months, their condition might change when they're 15 years, 11 months, especially for young people where things can change quite quickly. So we would want the assessment to be as recent as possible. So we wouldn't want to go more than a month, because then we might have assessments that are outdated. So that's why it's 1 month period.
Okay. Alec, are you indicating?
Yeah, thank you, Chair. Thank you for your presentation. Just one question: the decisions of the panel. Page 88, or number 11, well, 11, it's a bit confusing on this. Number 2, point 46, the panel is not required to provide formal justification of its decisions. I don't agree with that. I think they should be justifying their decisions.
So the reason for that is they don't need to make a formal judgment in the same that a judge or a tribunal would. The evidence why a trust panel should authorise must be in the paperwork. If they're not content that the paperwork provide enough evidence, they cannot authorise the DOL. So the reason for the DOL, or deprivation of liberty, is in the paperwork that comes to them. We have then developed regional paperwork that the trust panel has to use, where there are comment boxes where they say why not they're doing what they're doing, but it's not a formal judgment in that sense.
Okay, but say the panel go against the decision that's already been made, should there not be some documentation to explain that?
Yes, and then there is documentation, there is comment boxes, there is reasons why.
Those boxes?
Yes, I mean the expandable boxes, there's reasons why, but it's not a formal written judgment as a tribunal would have, because they're healthcare professionals that are not. The panel is not a legal panel; it's a trust second opinion system rather than a formal scrutiny. Of course, we have the tribunal system, the Attorney General tribunal system that comes after the panel. So the regional documentation that provides the format for the trust panel documentation includes justifications, but it's not a formal statement in that sense.
So, say in theory somebody's held and the trust want them held, and it goes to the panel to make a decision as well, and the panel decide to hold them as well, but we'll call them a patient.
Yeah, sure.
Patient decides to go down the legal route. Are the legal representations allowed to have access to the paperwork then on the panel?
They are, yes. However, the tribunal will look at the original paperwork, so the paperwork that came down to seek that from the professional made assessments. Mm-hmm. The panel do not make assessments. The panel do not see the patients. Yep. They're basing their fact on, or their decision on, the paperwork that's gone to them. So the decision is being challenged, or the decision is being taken to the tribunal. What they're looking at is the paperwork, the original paperwork, so the medical reports, the formal assessment of capacity made by a healthcare professional, because they're the ones who have seen the patients. So that's what the tribunal based their decision on, that's what the tribunal will base their understanding of the trust panel decision on. They won't base it on the trust panel decision itself, because the trust panel's review mechanism within the trust.
Okay. Okay. No problem, that'll do. Thanks.
Thank you. I have John and then Pam.
Thank you, Chair, for letting me back in. It's just relating to the money and valuables section under point 2. For the purposes of section 275 of the Act, it appears to be, if it appears to a relevant authority, the word appears to me sounds quite subjective, quite broad. Is there anything more tied down in that in terms of a process for the assessment of how that relevant authority would make that assessment rather than just appears to be? You talked about flowcharts earlier on within training. How is that decision informed and then decided upon?
The They have to assess capacity in lines with the capacity test that's in the first sections of the Act.
Okay.
So there's a statutory capacity test that they have to consider.
Okay.
They have to have reasonable belief that the person lacks capacity, and that's where the language with peers comes from.
Okay.
But they still have to follow a statutory test that's in the Act.
Okay. Thank you.
Thank you, Chair, and thank you, Thomas. I don't have a question for you. It was just to say that I was had the misfortune of sitting on the ad hoc committee, which was scrutinising the mental capacity bill, and it's an absolute minefield, and it's so complex. So it was just really to thank you for your time here today, because it's an incredibly detailed piece of legislation. So the regulations are naturally going to follow suit and be very complicated. So thank you for your patience with us.
And I have just a couple of things, Tomas, as well. There was mentioned there in your presentation to a cost of around about $3 million annually, but has that additional funding been actually allocated at this stage, and does it allow for backfill into the teams which will be affected?
Yes, I mean, we have allocated 1.56 million this year as in-year effect, and we've fully committed to fund it next year as well to backfill the posts. We have agreed with the Trust to review costs at the end of this financial year and continuously throughout next financial year, as there are some uncertainties of exact volumes, as this is unknown to all of us. But we are providing funding to backfill costs. There is obviously a problem with staff availability to backfill, as we're all fully aware of, but the funds have been provided.
And final one from me in terms of, and you did again mention this in passing in your presentation, but given the complexity of this issue, and given I think that we all hope to see significant improvements in how this whole area of life is managed as a result of these statutory regulations and the more substantive Act. But you mentioned a review, but when is that review planned?
So there is two kind of set of reviews ongoing. One is a continuous review. We're going to make a formal review as well. We don't want to set a date for a formal review yet, because it depends slightly on how the ongoing reviews are going. We don't see the need to review something that we know is not working well, or that we know when we know the problems are. There will be a formal review. There will be post-project evaluation, as there is with all projects. I would envisage that we'll be looking at that formally at least no later than the year after commencement. So we'll be looking at that, how it's going in December. But I don't want to set a date, as it might depend on, we might want to do it quicker. If we feel there's a need to do it quicker, we might want to delay it slightly because we have initial teething problems that we know we're going to come over. So instead of setting a fixed date, we're committing to do it. We're just not committing exactly one.
Okay, and thank you for that. And I suppose we will ongoing, despite whatever happens today and whatever the decisions are today, it's such a significant issue out there in the community that we will continue, I suppose, to keep an eye on that. So, of course, I'd like to thank you for your very comprehensive presentation and for how you've dealt with all the questions very directly, I think. So, thank you for your time.
Thank you.
Appreciate that.
Thank you.
Okay, members, thank you for that. It was, are there any, before we start to go into putting each of the individual, the question on each of the individual, are there any further comments at this stage that anyone wants to?
The question will have built into it that we are referring to the examination from, because I think that's a big piece on this for us now, that technical scrutiny. You know, it is pending that we make that clear. But that is inbuilt in the question, I understand, isn't it? Yeah, okay.
It's not inbuilt into each individual one we have dealt with, is it? It's built into each. It's built into each, okay.
Yeah.
So it will be built into each one. And I need to read the... Yeah. Okay, so if we're ready to start then, 6.2 is SR, Statutory Regulation 2019-163, the Mental Capacity 2016 Act, Commencement Number 1, Order, NI 2019. I refer members to pages 63 to 68 of the pack. These regulations provided for substantial provisions of the Mental Capacity Act 2016 to come into effect from 1st of October 2019. They were, as discussed, amended to provide for a later commencement date of 2nd of December 2019. Are members content to note that statutory rule? 6.3 SR 2019/190. the Mental Capacity 2016 Act, Commencement Number 1 Order, Amendment Order 2019, and I refer members to pages 69 to 74 of the pack. These are the regulations that deferred the commencement of certain provisions from the 1st of October until the 2nd of December 2019. Are members content to note the statutory rule?
Agreed.
SR 2019/164, the Mental Capacity Deprivation of Liberty Regulations, NI 2019. I refer members to pages 75 to 137 of your pack. These were the principal regulations providing for the procedure around deprivation of liberty, including suitably qualified persons, make capacity assessments and the required forms. They were subsequently revoked as discussed. Since they have been revoked, these regulations are for noting but have been included in the pack for the record. Are members content to note the statutory rule? Number 8, SR 2019/182, the Mental Capacity Deprivation of Liberty Amendment, Regulations NI 2019. I refer members to pages 138 to 148 of your pack. These regulations added an additional form to the principal regulations. Both were subsequently revoked. Since they have been revoked, these regulations are for noting but have been included in the pack for the record. Are members content to note the statutory rule?
Yeah.
SR 2019/192, Mental Capacity Deprivation of Liberty Revocation Regulations, NI 2019. I refer members to pages 149 to 155 of the pack. These regulations revoked the principal regulations as discussed ahead of their replacement in later regulations. Are members content to note the statutory rule? Number 10, SR 2019/199. The Mental Capacity Deprivation of Liberty Number 2 Regulations, NI 2019. I refer you to pages 156 to 205 of the pack. These are the revised principal regulations providing for the procedure around deprivation of liberty, including suitably qualified persons to make capacity assessments and the required forms. Are members content with the statutory rule?
Yeah.
If so, can I ask the members to agree formally that the Committee for Health has considered SR 2019/199, the Mental Capacity Deprivation of Liberty Number 2 Regulations 2019, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
11. SR 2019/232. Mental Capacity Deprivation of Liberty Number 2 Amendment Regulations, NI 2019. I refer members to pages 206 to 216. These regulations amend the revised principal regulations to substitute Form 6, which relates to medical reports. Are members content with the statutory rule? If so, can I ask the members to agree formally that the Committee for Health has considered SR 2019/232, the Mental Capacity Deprivation of Liberty Number 2 Amendment Regulations, NI 2019, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
Number 12, SR 2019/193, the Mental Capacity Research Regulations 2019. I refer members to page 217 to 222 in your pack. These regulations define the appropriate body for the purposes of research as a body appointed by the HSE Trust or a university. Are members content with the statutory rule? If so, can I ask members to agree formally that the Committee for Health has considered SR 2019/193, the Mental Capacity Research Regulations, NI 2019, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
Number 13, SR 2019-200, the Mental Capacity Act, Money and Valuables Regulations, 2019. I refer members to pages 223 to 229. These regulations extend to any managing authority the power These regulations extend to any managing authority the power trusts have to hold and manage money and valuables on behalf of residents and patients lacking capacity. The regulations also make provision as to the issues to be considered and formalities to be observed. Are members content with the statutory rule?
Content.
If so, I will ask members to agree formally that the Committee for Health has considered SR 2019/200, the Mental Capacity, Money and Valuables Regulations NI 2019, and, subject to the Examiner of Statutory Rules report, has no objection to the rule. Are we agreed?
Agreed.
Okay, members, thank you for that. We are now going to move on to the misuse of drugs regulations. So we're moving on to the next group of statutory rules here, dealing with the misuse of drugs. I'd like to invite Canis Ward from the Medicines Regulatory Group at the Department of Health to brief the committee on the regulations. So Canis, you're very welcome here, and thank you for your time.
Thank you, Chair.
And we'd like to invite you to make your presentation, please.
Okay, I think it'd probably be useful to give a bit of a brief background on misuse of drugs legislation on the whole. The Misuse of Drugs Act is a primary piece of legislation that's from 1971. Primary purpose is to prevent the misuse of harmful drugs, which are liable to misuse and abuse. It's largely penal in purpose, so it's used for criminal purposes, and it classifies drugs into Class A, B and C for criminal or penal purposes. It's a reserved matter for the Secretary of State, for the Home Office. So the Home Office make primary legislation to control drugs under the Act. Regulations then relax not all, some restrictions upon the Act to allow for the drugs to be used for legitimate purposes, such as healthcare. So in Northern Ireland we have our Misuse of Drugs Regulations, Northern Ireland 2002. The equivalent regulations in GB are the Misuse of Drugs Regulations 2001. They're the responsibility of the Home Office, but in Northern Ireland the regulations are the responsibility of the Department of Health. So the regulations, again, they allow for the use in healthcare of drugs that would otherwise be dangerous. In 2018 and 19, I think we've made a number of amendments, really over 3 policy areas. In no particular order would be relaxing some of the restrictions on cannabis-based medicinal products, the scheduling of gabapentinoids, drugs such as gabapentin and pregabalin, and then just some minor amendments to keep up in line with the GB legislation that includes additional prescribers of controlled drugs and controlling some other products that wouldn't necessarily be used in healthcare. So that's a brief background of the overarching legislation. Was there a particular statute or SR that members wanted to discuss?
Well, I suppose at this point we can invite members to ask any questions that maybe that have arisen from their examination. Is this solely adding drugs into, and you see, in terms of the prescribing, are nurse prescribers, and I'll declare an interest, my wife is a nurse, but are nurse prescribers included within the scope of these statutory regulations?
Of the amending regulations,
yeah.
Or not the amending regulations, but on the regulations as a whole, nurse independent prescribers are able to prescribe controlled drugs.
Okay.
But there was no specific amendments in 2018 or 19 relating to nurses.
Jerry, first and then Sinead, sorry.
Sure, thanks. Well, it's just a clarity for my sake. Is methiopropamine, if I pronounced that correctly, under this regulation, I think that's going to be banned currently, or if you could clarify that for myself, please.
Is that in one of the specific amendments?
Yeah, sorry. I think it's on the second page of your letter, I think, to Eilish. It's the legal high. It references about it being linked to the number of deaths in Scotland up until 2015. My understanding is from the regulation is that that drug is going to be made illegal, is my presumption. Just a bit of clarity on that.
Is that in, could you read out the statute?
Which regulations are into there?
242.
242, page 242.
Can you call out the statute, please?
Bear with me.
Yep. Bear with me as well.
Yeah.
So it's 2018/3, Janice?
Yeah. Well, that, when it becomes controlled under misuse of drugs legislation, it becomes a controlled drug, so it will essentially be banned as such. You know, for want of a better word, it's controlled. So there's, you know, greater penal or criminal sanctions associated with its misuse and, you know, unlawful selling and importation, etc. But
thanks for that clarity and the patience there. Just
our
packs are quite big, and I know we don't have the same one. Was there any consideration, if not by yourself or by the department, of the potentiality of driving potentially users or these drugs underground? Was that part of the consideration from the department, if you're aware of?
I probably should have said at the start, amendments to misuse of drugs legislation in Great Britain or in NI are made only after consultation with and recommendation of a arm's length body, an advisory council on the misuse of drugs. So they're a statutory body made under the Act, almost an arm's length body of the Home Office. But ministers or departments will or can only make amendments after consideration and recommendation from the advisory council. So it would be for the advisory council to consider, you know, potential driving drugs under, you know, seeking alternative sources for that. But if that was the case, you know, by controlling it, if people are caught, or, you know, it gives the police greater powers and it gives greater sanctions if people are, you know, misusing or selling or dealing with such drugs.
And I think obviously there's a greater extension, I think, from cannabinoids. I think that's important. Obviously, there's a lot of high-profile cases around medicinal cannabis. But I think, just to clarify, Chair, there's a consultation on all the changes. I think there was a section where you mentioned there wasn't, or there was minimal consultation. Just to clarify, to the best of your knowledge, the level of consultation that took place. I appreciate that.
There were various amendments of talking about the gabapentinoids, and pregabalin and gabapentin. There was a UK-wide consultation. Specifically cannabis, there wasn't a consultation across the UK, and certainly not in Northern Ireland, but I think it was how rapid it came in, really, you know, the lack of time as such. But certainly in Northern Ireland, we would call it a mini consultation. We engage with any stakeholders with an interest in controlled drugs. The department's represented at a statutory forum called the Local Intelligence Network. It's set up under different controlled drugs legislation, but it has all the main stakeholders from any of the trusts, say the pharmacies in the trusts, the police, independent hospitals, health and social care boards. There are a lot of persons or organisations represented at that have an interest in controlled drugs. So it wasn't a consultation as such, but it was a stakeholder engagement, and it's probably the best we could do at given the time frame.
And just finally, Chair, thanks for your patience. As far as you know, there wasn't a consultation on the methylpropamine.
As far as I'm aware, there wasn't, but I can get back to you.
Please.
Yep, no problem.
Thanks, Chair.
Just for context in relation to that, how often is this process undergone by yourselves in terms of new drugs coming on, either illegal or legal drugs coming on? How often is this process engaged in, just to create a context for these?
It's an ongoing engagement. It would be a number of times a year. It's ongoing from that, you know. It's
okay. Sinead.
Okay. I suppose I'm curious to know, I mean, there's quite a long list there of the types of drugs that you're referring to, and if it is an ongoing, I appreciate, you know, I'm sure there's a technical description of what that is, you know, in terms of what is a controlled drug as opposed to a drug that's on the street that maybe may legally come under this name. So what I'm getting to and what I'm leading to here is under the purpose of this, I suppose, is to keep people safe. Ultimately is the objective. And then I look at one of the outcomes on the, the anticipated financial implications, and it just refers to the Department of Health that there won't be any. But has there been consideration to, if this is about keeping people safe, it's one thing putting it in the statute books, but it's a very different thing to actually monitor it, manage it, police it, and follow it up. So there must be consequences to that. And I'm not saying that's a bad thing, because I think the objective of saving lives, will override that. But it seems that there's a broader picture here that we're maybe not seeing. This just appears to be quite technical in that it's a list of current drugs at this time that need to be listed.
Yes.
But is there an effort to put it in a broader framework?
I suppose it harks back sort of to the opening statement that the Misuse of Drugs Act, the criminal purpose of the penal statute, the primary legislation, it's a reserved matter, so those matters are undertaken by the Home Office of the criminal impact or the wider impact. The regulations, as you say, they are quite technical and specific, but they are relating to legitimate use.
Yeah.
By scheduling these in Schedule 1 with all these strange names, it really means they can't be used in healthcare.
Yeah.
And that's it.
Okay.
There
So it doesn't go into
no,
okay.
but the larger impact assessment would be undertaken by the Home Office when they're controlled under the Act as such, primary legislation. So,
okay, so to get that right, so this purely looks at the medical world.
well, legitimate use, but primarily legitimate.
Yeah.
Or it could be research, it could be forensic science, but primarily it is health purposes.
Okay, thank you.
Okay. Gemma?
No, it's okay, thanks. My question was on around the consultation stakeholders, but you've answered that, so thank you.
Thank you, Gemma. Orlia?
Yeah, thank you. I'm not sure how relevant my question is, so forgive me on my ignorance on this because I'm not a medic. The issue around the prohibition on cannabis smoking, would there be any conflict there with the way the debate's taken place with the use of cannabis for medicinal purposes? Would there be any sort of issues there with banning the use of cannabis through smoking it? I'm not sure if that would even be an option for someone that would need to be prescribed it for a medical reason, but it was just to see if that was...
I think that the specific amendment you're referring to is about cannabis-based medicinal products, so it is about a medicinal use, and I think widely knowing that smoking as a whole is bad for you, so that's the reason that was brought in.
Okay.
That is interim guidance or amendment, so there could be further amendments in due course, but probably couldn't see a reason why you would need to smoke it, and I think it is to differentiate it and then help others in law enforcement to, if they see somebody smoking cannabis, that they can't say this is for a medicinal purpose, is to differentiate that's not the reason for that.
Okay, fair enough. Thank you.
Okay, thank you. Before I became an MLA, I worked in Belfast City Council, and at that time, sort of 2014-15, that's whenever the head shops were at their busiest, and the new psychoactive substances, legal highs, were rife on the streets. And at that time, we were advised by the police and others that they would just change one wee small substance, and then they would be able to be legally sold again, and it was almost like a race around the clock on that. I'm just wondering to what degree these regulatory changes will actually prevent that from happening. Is it far-reaching enough that even with a small tweak in it, that everything will be covered?
I think, as you say, you've alluded to the misuse of drugs regulation is quite technical. It does name specific compounds and nomenclature. But you did allude to the Psychoactive Substances Bill now in Act. It has a blanket prohibition on any psychoactive compounds, so it wouldn't be covered by misuse of drugs legislation, but rather by the Psychoactive Substances Act now. So if somebody was to be really clever and change a chemical group, it would be covered no matter what under not under misuse of drugs, but under the Psychoactive Substances Act.
Well, thank you. That's it.
Are there ongoing research into further uses, medical uses for cannabis? Is that an ongoing piece of work?
I think part of this amending legislation, cannabis as a whole and cannabis-based medicines were placed in Schedule 1 to the misuse of drugs regulations, which meant basically there was no recognised use for them, or there was no purpose for them, and as such really research could only be undertaken under licence from either our department or the Home Office. It was quite restrictive, but by moving them into Schedule 2, some of the restrictions are relaxed to allow for further research and limited prescribing. But by moving them into Schedule 2, this legislation does promote such research, and there has been further calls for research, so it promotes that as such.
Thank you. I have no other indication from members, so I just want to thank you, Kenneth, for your presentation, and thank you for taking the time from us.
Thank you.
All the best. Goodbye.
Thank you.
All right.
Thank you.
Thanks.
Okay, members. Then, if are there any further, if there are no further issues in relation to that, and I'm not sensing that there are, can we move into considering each of them in turn and formally putting the series of questions? Happy with that? Yeah. Okay, number 14. SR 2018/3, the Misuse of Drugs Designation Amendment Order NI 2018. I refer members to page 230 to page 246. This statutory regulation adds a number of substances to Schedule 1 of the Misuse of Drugs Designation Order 2001 regulations, as they have no recognised medicinal use beyond potential research which may be enabled under a licence. These substances include so-called legal highs and anabolic steroids. Are members content with the statutory rule? Yep. If so, can I ask members to agree formally that the Committee for Health has considered SR 2018/3, the Misuse of Drugs Designation Amendment Order NI 2018, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
SR 2018/4, the Misuse of Drugs Amendment Regulations NI 2018. I refer members to pages 247 to 261. This regulation adds a number of substances to Schedule 1 of the Misuse of Drugs Regulations 2002. These substances include so-called legal highs and anabolic steroids. Are members content with the statutory rule? Yes. And if so, can I ask members to agree formally that the Committee for Health has considered SR 2018/4, the Misuse of Drugs Amendment Regulations NI 2018, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed? SR 2018/173, the Misuse of Drugs Amendment No. 2, Regulations 2018. I refer members to pages 262 to 270 of the pack. The next two instruments amend the Misuse of Drug Regulations 2002 and the Misuse of Drugs Designation Order NI 2001 to provide greater access to cannabis-based products for medicinal use in humans. Are members content with the statutory rule?
Content.
If so, can I ask members to agree formally that the Committee for Health has considered SR 2018/173, the Misuse of Drugs Amendment No. 2, Regulations 2018, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
Number 17, the Misuse of 2018/174, the Misuse of Drugs Designation Amendment No. 2, Order NI 2018. I refer members to pages 271 to 278. Are members content with the statutory rule?
Yes.
And if so, can I ask members to agree formally that the Committee for Health has considered SR 2018/174, the Misuse of Drugs Designation Amendment No. 2 Order NI 2018, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
SR 2019/21, the Misuse of Drugs and Misuse of Drugs Safe Custody Amendment Regulations 2019. I refer members to pages 279 to 289 of the pack. This SR adds pregabalin and gabapentin to Schedule 3 of the 2002 regulations controlling use, etc., but exempts them from the provisions of the safe custody legislation, which requires them to be kept in a locked safe. This is in recognition of the large quantities dispensed for legitimate medicinal use, which would impact the work of pharmacies and add costs, etc. So are members content with that rule? If so, can I ask the members to agree formally that the Committee for Health has considered SR 2019/21, the Misuse of Drugs and Misuse of Drugs Safe Custody Amendment Regulations NI 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Are we agreed?
Agreed.
SR 2019/207, the Misuse of Drugs Designation Amendment Order 2019. I refer members to pages 290 to 297. This SR amends Part 1 of Schedule 1 to the Misuse of Drugs Designation Order NI 2001 by reducing the range of compounds captured by one of the definitions of synthetic cannabinoids in Schedule 1 to that order, which specifies the list of controlled drugs to which Section 7(4) of the Misuse of Drugs 1971 Act applies. Are members content with the statutory rule? If so, can I ask members to agree formally that the Committee for Health has considered SR 2019/207, Misuse of Drugs Designation Amendment Order NI 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
SR 2019/208, the Misuse of Drugs Amendments Regulations NI 2019. I refer members to 298 and to page 314 of the pack. These regulations make a number of amendments to the 2002 regulations to ensure parity with their GB equivalent regulations. The amendments include amending the generic definition of a range of synthetic cannabinoids, introducing limited prescribing powers for certain controlled drugs to specified independent prescribers, extending the authority to supply or offer to supply controlled drugs to senior registered nurses in charge of juvenile justice centres and prison healthcare departments and midwife ward managers, and providing authority for the NI Ambulance Health and Social Care Trust to produce and supply Schedule 2 to 5 controlled drugs directly to their registered paramedics for use in the immediate treatment of sick or injured persons. Are members content with the statutory rule? If so, can I ask members to agree formally that the Committee for Health has considered SR 2019/208, the Misuse of Drugs Amendment Regulations NI 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed?
Agreed.
Okay, thank you, members. We are now moving on to SR 2019/42, the Provision of Health Services to Persons Not Ordinarily Resident Amendment Regulations NI 2019. We now move on to the next statutory rule, members, dealing with the provision of health services on and after EU exit day. I refer members to pages 315 to 331 of the pack, and I would now like to invite Patricia Quinn Duffy, and you're very welcome here, Patricia, from the Department of Health to brief the committee on this SR. Thanks, Patricia.
Thank you, Chairman. This SR was laid in preparation for a no-deal exit, in preparation for the first exit date of 29th of March 2019. It's a regulation to amend the provision of health services to persons not ordinarily resident Northern Ireland regulations of 2015, which provide exemptions from charging to healthcare for certain visitors who come to Northern Ireland. The regulation was to amend in terms of a no deal where EU regulations would no longer apply, so it was to remove initially references to EU regulations which wouldn't apply, and also to make provisions for people who have rights that was felt that should continue in the event of a no deal where possible, such as frontier workers, retired cross-border frontier workers, students who are studying already, either at school, university. And that's what the regulation is designed to do. The reason why it was laid in the Assembly, there were some difficulties and delays in coming to a UK-wide agreement on certain exemptions, which meant that using the Withdrawal Act would have delayed the implementation of the regulations until well after the 29th of March. So the decision was made to use the Northern Ireland legislation to ensure that the cohorts of people in Northern Ireland could still attain their health care without charging as they were at the time and currently do. This regulation has a commencement date of exit day, which has been deferred through amendments to the Withdrawal Act. When the Withdrawal Agreement Bill is due for Royal Assent today, and it will be deferred until the end of the implementation period. That's really, in a nutshell, what this is to do. Whether or not this will actually remain until the end of implementation, I imagine there will be a review. It's just to say to the committee that there will probably be a review of this to make sure that it still is relevant in terms of the negotiations that are going to happen within this year, and that anyone who has an exemption still keeps the exemption, because obviously the Withdrawal Agreement Bill will enshrine a number of rights for people who are already here.
And am I right in thinking, Patricia, that this was designed to deal with a no-deal scenario?
Yes.
But now it has almost been rolled on in any case into a situation where we now are looking potentially at there will be a deal?
There will be a deal. It will be deferred until the end of the implementation period. But during that implementation period, there will be negotiations ongoing between the UK and the EU. And whatever comes out of that, there may be changes to this, either additions, and also, because that's the sort of international agreement, there also may well be decisions made here as to what Northern Ireland decides to offer.
And I suppose there would be an understanding that there will be, issues with people from across Europe travelling or working back and forth. We have an additional complication here. Yes. In terms of we have an entire border corridor. Yes. And beyond of people who traverse the border regularly to work, live, to get married, to care for relatives, and all that involves, often paying tax on the northern side. And there is a concern around the issue that this would only apply to people who are currently in that, and that any future job opportunities, students would be therefore deprived of the rights that are currently exist.
Yes, this legislation was in the matter of a no deal, and was for the people who were already having rights. Those decisions would be something that would have to be looked at within the implementation period and would not be subject to this piece of legislation.
Just finally from me, before I go to Gemma, what consultation has been completed in relation to this?
As with the EU exit legislation, there was no consultation carried out on this legislation.
Gemma, and then...
Chair, thank you, and thanks, Patricia. What might seem like an obvious question, but when is exit day? Is that the 31st of January, or...?
Yes, the 31st of January is exit day.
Yeah.
With the Withdrawal Agreement Bill, they're deferring any EU exit no deal legislation until the end of implementation period, which is the 31st of January 2020.
Yeah. Okay.
Or 31st of December 2020.
Just on another note, Chair, I think, as you've mentioned, in terms of cross-border workers, but with workers and students and visitors from across Europe, this is such a complex matter. And I know we spoke earlier about our time limitations, but I think this needs further scrutiny. And I would be proposing that we could push this back a week to look at this in further detail.
Well, we'll come back to that, Gemma. Just once we'll go to other members for questions, and then we'll come back to that. There, I have Paula next, and then Sinead.
Thank you, Patricia. And I have to say, the presentation you gave us a few months ago was very useful in terms of your preparing for EU exit. Just two quick questions, really, about is there going to be reciprocal arrangements across the border?
The UK and Ireland have opened negotiations on a longer term reciprocal arrangement, so that is underway.
But will it be in effect on the 1st of February?
No.
For
the 1st of February, all EU legislation will apply as currently, so there will be no changes to rights or access until the end of implementation period, which will be 31st of December 2020.
And then the second part then, so does that mean then the Border Healthcare Directive, will that still be in place then?
That will still be in place until the 31st of December this year.
Okay, so if people have got their applications in now, it'll still be, okay.
They will, yeah.
Okay, thank you.
Sinead?
Thank you. I take, thank you, Patricia. I appreciate the information so far, but I take note that you're saying there was no consultation. I suppose I'd like to understand better the thinking or the author behind this as presented, and also the implications of. I appreciate that there will be negotiations going on, and it is almost a temporary piece of legislation to fill a legislative void. But is there any likelihood of an impact on those negotiations? For example, what came to mind to me was an EU student in Dublin coming north, for a trip or some sort of a experience linked to their studies. And if they're in this part of the island and had a fall and are presented at accident and emergency, after this period, that would exclude them, if I'm right.
Yes.
And and I really just think there seems to be a real obvious lack of a logic that we live in an island.
There are a lot of people who would not be exempt under the UK. When the UK leaves the EU, there would be a lot of people that would not be exempt. The idea behind these amendments was to try and to establish for the main groups of people who have current rights, who are such as frontier workers, cross-border workers, retired cross-border workers, and people who are studying currently, that they can continue to do so and not be concerned about what happens to their healthcare after exit. What happened in the new scenario would be a new relationship, and we didn't consider those decisions because they really are a decision that a minister should make and should be made on behalf of Northern Ireland, also in connection then with whatever the UK EU come to an arrangement on.
I just do think it, on first glance, to me, it seems very lacking. And I take it for what it is. I see it being the temporary measure or the plug, but I'm not sure that it's encompassed enough, even as that, even with that weight on it.
It doesn't cover everyone.
Yeah.
I mean, to be very honest about that, it does not cover everyone who would have had a right currently in a no-deal scenario. They would not all have transferred. Really, because the reciprocity would not be there. So a Northern Irish person travelling to Ireland or to the rest of Europe without a reciprocal arrangement would not be entitled to the same conditions if we had continued the whole of the range of healthcare provision. But those are the decisions that are being negotiated on a UK-EU basis, and also the no deal was trying to get UK-EU bilaterals. There were lots of negotiations ongoing on those, and they were accounted for in this, so there would have potentially have been certain countries that had coverage. It's very complicated and convoluted, but it, as I say, it doesn't cover everyone in every circumstance that they would have currently.
Okay. Sure, because just, I appreciate there would even be costings would have to be worked through in terms of the options, but I do have concern that if we set this as a marker in place whilst those delicate negotiations are happening and we're talking about reciprocal arrangements, you know, I certainly wouldn't like to be visiting, or you know, the person at the other side of this. You know, there could be, I think, a further reach out to making sure that the landing place for any reciprocal relations in the longer term are a lot more generous than this.
John?
Thank you, Chair. Thank you, Patricia. I agree with a lot of what has been said there. I think initially we probably found this under hopefully never required, because this was a document that was prepared in the eventuality of what could have been a no deal prior to where we got to Brexit deal and then the transition period. The status quo will remain in every way, shape or form that we currently know until the 31st of December this year. And this document, even at that point, if the full detail of that deal between the UK and the EU then is ironed out, we'll hopefully deal with everything that's in this, so it will not be required. And if it doesn't, this document will be completely updated, either edited, updated or amended, whatever way, you know, in terms of the detail of it. So it will be hopefully much more comprehensive. So while I'm sympathetic to the proposal, I think it's duly good to note what's in here, take what bits are good, realise how much is missing, looking towards what might happen towards the end of this year, and then somewhere before that, if it looks like we're going towards that cliff edge, make sure that we take everything on board of what's been said and make sure this document is fit for purpose then. But I hope it never needs to see the light of day, Chair, because it would be worrying for all the reasons people have pointed out and all the things that are lacking from it, just how poorly informed we would have been and prepared we would have been. Thank you.
And I suppose in relation to, you'd mentioned there, Paula, that, or Patricia, sorry, that there are some cases where reciprocity is not in place.
Yeah.
But we could also attract negative in terms of doing this, and then, and there are elements of this out there already in the community, you know. So I think we do need to be really careful. I'd suggest if there's no other questions for Patricia at this stage, we'll let Patricia. Oh yeah.
Just ask on the back of the query so far, what would be the implication if we did defer this for a week at this stage, given this is our first meeting back after 3 years?
If it is deferred, if the withdrawal agreement bill gets royal assent today, this legislation would not be commenced until the end of the year in any respect. So there, potentially, I'm not sure that there would be any difficulties. We're expecting it to get royal assent today. If it doesn't, which I doubt very highly unlikely. So yes, I don't think there's anything I can say that would...
And would it be fair to say then also, if we go ahead with it today,
it still won't be commenced.
It still won't. There'll still be no impact.
Yes.
Here nor there.
Can we take some advice from Clerk in relation to that?
Just to confirm that there is time under in terms of the statutory period, we have another meeting or two in hand when you could come to a final view on this if you should wish to defer consideration.
Okay, well, we'll consider. I think we could let Patricia go if there's no other questions raising. We'll thank you, Patricia.
Thank you.
Okay. So, happy to hear all the views, but I think there is a kind of a feeling there where there's, in this particular one, there's a lot of potential complication. Maybe deferring for a week would allow everyone to have a bit of a better and a quicker look. I'm very conscious we've all been brought very quickly into this meeting. Yeah.
Just following on the comment about to Patricia there, the Department of Health did provide a briefing about their scenario planning for no-deal Brexit, and it was very useful, and it looked at pharmaceuticals and it looked at workers' rights, and I wonder even if we could get an updated written copy of that report, because I think it would put a lot of this stuff in context, because I thought this was a wee bit too standalone and didn't really, you know, the healthcare, the cross-border work and stuff. So it could go in the committee pack for next week that would sit alongside this and put a bit more context around it.
or indeed, given that level of should we put it back to? Do we have 2 weeks meeting at this stage, Clerk? That we could we put it back to 2 weeks' time, or would it be better to bring it back?
Our suggestion was to try to address what we could by next week, so that the 3rd week is there if there's any hitch or problem.
Okay. Okay, I think we do have broad agreement that we defer this particular item back to next week's meeting. Are we agreed?
Yeah.
Okay. Moving on, basically to we have dealt there with a number of those lower 20s, and we're now on to 25, which is SR 2019/109, and this is in page 358 to 370. And it's SR 2019 Firefighters Pension Scheme Amendment and Transitional Provisions Order NI 2019. And this rule amends the Firefighters Pension Scheme Order to address possible age discrimination as a result of the Employment Equality Age Regulations 2006. So, it's basically an attempt to ensure that there is no discrimination based on another piece of legislation. Am I correct in that, Clerk?
Yes.
Yeah. So, are members content with that statutory rules?
Yes.
If so, can I ask members to formally agree that the Committee for Health has considered SR 2019/109 Firefighters Pension Scheme Amendment and Transitional Provisions Order NI 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Are we agreed?
Agreed.
I think now we're moving on ahead into these. I think these were all of them more of a technical nature, but if members have any other views on them as we move through, they can. But I'm going to start going through those other amendments now, which are in your pack. They're in the pack from pages 371 to 377. The first one of these is SR 2017/188, the Pharmaceutical Society of Northern Ireland General Amendment Regulations NI 2017. This statutory rule enables the Register of Pharmaceutical Chemists to be annotated to indicate that a pharmacist is an independent prescriber and clarifies the role of pharmacist supplementary prescribers. Are members content with the statutory rule?
Yep.
And if so, can I ask members to formally agree that the Committee for Health has considered SR 2017/188, the Pharmaceutical Society of Northern Ireland General Amendment Regulations NI 2017, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Are we agreed?
Agreed.
The next one is SR 2019/186, Pharmaceutical Services Amendments relating to Serious Shortage Protocols Regulations NI 2019, contained within pages 378 and 389. These regulations provide for serious shortage protocols to allow the Department to put in place alternative arrangements for the supply of medications and appliances where a serious shortage arises. Are members content with that rule, Chair?
Yes.
If so, can I ask members to agree formally that the Committee for Health has considered SR 2017/186, Pharmaceutical Services Amendments relating to Serious Shortage Protocols Regulations NI 2019, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Are we agreed?
Agreed.
SR 2018/17, the Ionising Radiation Medical Exposure Regulations NI 2018, and I refer members to pages 390 to 420 of your pack. This SR transposes medical exposure aspects of European Council Directive 2013/59/Euratom, updating, consolidating and enhancing standards to protect those undergoing radiation therapy, X-ray or other screenings. Are members content with the statutory rule? If so, can I ask members to agree formally that the Committee for Health has considered SR 2018/17, the Ionising Radiation Medical Exposure Regulations NI 2018, and subject to the Examiner of Statutory Rules report, has no objection to the rule. Are we agreed?
Agreed.
29 SR 2017/207, the Northern Ireland Social Care Council Social Care Workers Prohibition and Fitness of Workers Amendment Regulations, NI 2017. I refer members to page 421 to 431 of your pack. This SR adds to the list of specified settings in respect of which compulsory registration of social care workers applies. These include domiciliary care, daycare centres and residential family centres. The regulations also exempt the volunteers from the requirement to register in specified settings. Are members content with that statutory rule?
Great.
If so, can I ask members to agree formally that the Committee for Health has considered SR 2017/207, the Northern Ireland Social Care Council Social Care Workers Prohibition and Fitness of Workers Amendment Regulations, NI 2017, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Are we agreed? Agreed. Number 30 here is SR 2018/123, the Northern Ireland Social Care Council Appointments and Procedure Amendment Regulations, NI 2018. I refer members to pages 432 to 437 of the pack. This SR amends legislation governing the procedures of the Northern Ireland Social Care Council to include its committees and subcommittees. Are members content with that statutory rule?
Yep.
If so, can I ask members to formally agree that the Committee for Health has considered SR 2017/123, the Northern Ireland Social Care Council Amendment, Appointments and Procedure Amendment Regulations, NI 2018, and, subject to the Examiner of Statutory Rules report, has no objection to the rule? Agreed? Agreed. Okay, members, we have also dealt with a number of those outstanding issues, and I am now looking to. I think we're moving in now, and thank you very much for it's been a long haul, but we're into now any other business. Do members have any other business they wish to flag up at this point? None noted. Thank you. And it's just now for us to agree the date, time and place of the next meeting. And can we agree the next meeting will take place at 10:30 a.m. on Thursday the 30th of January 2020 in the Senate Chamber, Parliament Buildings. And can I thank all members for your how you've dealt with these proceedings and the amount of work that we've got through and the collegiate fashion in which everyone has cooperated together. And thank you for your attendance, and I look forward to seeing you at the next occasion.
Thank you. Thank you.
Thanks, everybody.